Well, Safaricom came out guns blazing that they will not pay, they will not be covered by persuasive natures of sentiments of a magistrate. The Constitutional Court of Kenya, which is the apex court mandated to deal with violations of the Constitution in terms of any Kenyan whose rights have been violated. We rushed to court yesterday. We addressed the world and told them that Safaricom has turned itself into a law. And we told them that the Constitution of Kenya binds each and every person. Person meaning a human person, and any entity, a company, or any business organization. The judge has agreed with us that no data, no record, nothing of Mokaya can be disclosed to the DCI, can be disclosed to his girlfriend, can be disclosed to his fiancée, can be disclosed to anybody unless there is a valid court order. Only a valid court order. The judge is saying that must emanate from a competent court. And not only a competent court, a court with jurisdiction. In this country, the only courts that can allow Safaricom to release data to anybody, one, is the Supreme Court of Kenya. Two, the Court of Appeal of Kenya. Three, the High Court of Kenya. And lastly, a magistrate's court. Not any other court can order Safaricom to release data to anybody. No any other law, because the law, the written law, has given jurisdiction to the courts to give that. And therefore, they have been stopped. Remember, when we threatened to go to court, we were apprehensive that Mokaya can be traced, can be tracked, can be located, and be taken, abducted, and be killed. And that is why we rushed to court immediately to get an order to ensure that Mokaya's location cannot be traced by the DCI, it cannot be traced by Safaricom, it cannot be traced by enemies against Mokaya. This is a warning call to Safaricom. We did say that this is going to be a landmark case where the rights and the privacy and the data in the custody of Safaricom isn't protected by the law. The judge has agreed with us. Not only Safaricom, the Attorney General, who is a party in this matter, the DCI, who is a party in this matter, they have been given 2 timelines to respond. What we are telling the whole country, and keep watching, we will be vigilant. We are determined to fight to ensure justice for Mokaya is attained. We are sure that the judiciary, as promulgated in the 2010 Constitution, is independent, is fair, and we give Safaricom, and they have been given time to come and explain under which law, under which court order they gave the details of Mokaya. We said quite a number of Gen Zs, quite a number of the youths have been in this problem. Quite a number of marriages have broken. Reason because the wife or the husband or the boyfriend or the girlfriend have gotten data of their fiancés or of their opposite spouses, where they are, which Airbnb they are hiding. That is not the business of Safaricom, to track down and give data of where its customers are. This law firm deals with a lot of family matters. Safaricom is implicated in very many of those issues. Very many children in this country are suffering because the mother trailed the father to an Airbnb and the father ran away from home. He does not pay school fees to the children. Now Omari must go to court, Swiga must go to court to fight for those children. We are ready to proceed with this matter, and that is why we have given this exposure on the platform called Helicopter, the media house that does not fear to air the views to the public of Kenya. Kwa lugha ya Kiswahili nielezee, sababu wengi wa wale ambao wameathirika ni wale akina mama, wale vijana wa kujenga mjengo, wale wa kusukuma bodaboda pale, wale ambao wanasukuma mkokoteni, wale ambao ni wa mjengo pale. Sababu tunazozungumzia ni kwamba Mokaya aliweza details zake Safaricom iliweza kupeana kwa polisi. Polisi wakamshika, wakamleta, kesi imeendelea, Mokaya ameshinda polisi. Sasa tuko mahakamani kule Constitutional Court, ambapo tumeshtaki Safaricom kwa kukiuka sheria ya kwamba walipeana location na wakapeana data ya simu bila Mokaya kukubali. Mahakama Kuu inasema kwamba wasidhubutu tena kuanzia sasa kupeana ile detail yoyote ya David Mokaya. Na pia tumepewa taratibu na mwenendo wa vile kesi itakavyoendelea. Kwa hivyo ile kesi tutakuwa mahakamani, Court Helicopter itaweka wazi zile oda za mahakama. Tutakuwa macho, tutaangalia, sababu law firm yetu imesema itasimama na wana Kenya wale ambao wamedhulumiwa na Safaricom. Asante.
We are the firm of Dunstan, Omari and Associate Advocates, and we wanted to bring to the attention of the public the information that is emanating from a High Court petition number E126 of 2026, David Mokaya versus Safaricom and others. And on the 25th day of February 2026, at 14:46 hours, Justice Muamuye, who sits in the High Court Constitutional Division, has issued orders, and I will proceed to read the orders. The matter coming up in chambers for directions on the petitioner's application before the Honorable Mr. Justice Bahati Muamuye, and upon a preliminary consideration of the same, it is hereby ordered and directed that pending the inter-parties hearing and determination of the application dated 23rd February 2026, a conservatory order be and is hereby issued restraining the respondents and the interested parties jointly and severally, and whether directly or through their employees, servants, agents, or related entities, from transferring, sharing, disseminating, or howsoever otherwise divulging to any unauthorized person or party any of the petitioner's personal data, subscriber information, call and or location information, records, metadata, or such other information arising from the use of any telephonic or data device or service maintained by the respondent without either the petitioner's express written consent or either a valid court order issued by a court of competent jurisdiction or the reliance of an express provision of a written law permitting the same. That's the first order. The second order is the petitioner shall serve the respondent and the interested parties with the application, the petition and this court order, both in hard copy and soft copy immediately, and file an affidavit of service in that regard by close of business 27th February 2026. The third order, the respondent and the interested party shall enter appearance and file and serve their respective responses to both the application and the petition, and they shall do so by close of business 13th of March 2026. The petitioner shall have leave to file and serve a rejoinder if need be, and shall do so by close of business 27th March 2026. There is a mention on the 30th of March 2026 to confirm compliance and take directions on the expedited hearing and determine of the application and or petition. That is the upshot of the directions we have gotten from the Honorable Court, and we remain very vigilant to update the public on such a matter that touches on great public interest, especially in light of the gross violation of constitutional rights and freedoms.